Good afternoon, everyone. My name is Tom Bona. I'm a partner at Pillinger Tarallo, and I'm going to be the moderator for this afternoon's webinar. It's on resolving complex and multi-party litigation, part of our PMT St. John's Graduate School of Risk Management webinar series, conference webinar series. And we have a very, very good topic today, very interesting, because I think everybody always wants to find out how to best handle large cases, complex cases, multi-party cases. And so we have a great panel of very, very skilled experts who can give us their insights and help us gain knowledge about what should we do with these kinds of cases. Because sooner or later, perhaps every person is going to get one of these cases that's got a lot of people in it, a lot of claims, and this information could be very helpful and valuable. So I'd like to first thank the Tobin College of Business and the Greenberg School of Risk Management for their help and their support of our conference webinar series. I'd like to thank Brandon Schweitzer, who's a dean of the Greenberg School of Risk Management. I'd like to also thank Larry Pastel, who is the director of the Center for Executive Education, for his help putting our webinar series together. And of course, I'd like to thank Joe Levine and Rob Stewart from CC&G, which is PMT's branding and marketing partner, for their help in making this series happen and getting all the technical end of it worked out so we can present this to you. We have a great topic today, which is resolving complex and multi-party litigation, subtitled, "The bigger they come, the harder they fall." And we have a really great panel of experts. And I'd like to start by having our experts, our panelists, identify themselves and tell us a little bit about them, and then we'll get right into our topic. First, Jeff Miller, would you please introduce yourself?
Good afternoon, Jeff Miller, Pillinger Tarallo, and thanks for having us today.
Thank you. Neil Sambursky, could you please tell us a little bit about yourself?
Hi, everybody. Neil Sambursky, partner with PMT, run the Garden City office. Happy to be here today.
Scott Miller was going to be on, but unfortunately he's sick. So we've drafted another one of our partners from the New York office, Steve Kaplan. Steve, could you please introduce yourself?
Good afternoon, everybody. I'm Steve Kaplan, and as Tom just said, I'm from the New York office of PMT, and I'm one of the partners on Scott Miller's team.
Thank you. And from Buffalo, we have Ken Krajewski, who is very talented and has a lot of experience in this area. Ken, could you tell us a little bit about yourself?
Hi, everybody. I'm Ken Krajewski. I'm with Pillinger Tarallo's Buffalo office. I have about 30 years experience doing high-level asbestos defense work, so I'm quite familiar with resolving complex litigation and other things in our topic today.
Thanks, Ken. Joe Donahue, would you please introduce yourself?
Good afternoon, folks. How's everybody today? My name is Joseph Donahue. I'm a partner at the law firm of Block, O'Toole, and Murphy, and we handle plaintiffs' personal injury cases, catastrophic injury cases. And I want to thank PMT for inviting me here today. I'm a repeat customer, and I've always enjoyed it in the past. I'm sure I'm going to enjoy it today.
Thanks, Joe. And finally, Judge DiBlasi, another repeat customer. I want to thank him, thank all our panelists. But Judge DiBlasi, would you tell us a little bit about yourself?
Sure. And I'd also like to thank PMT for having me here today. Retired Justice of the Supreme Court. And after that, I came into my present incarnation as an arbitrator and mediator with National Arbitration and Mediation, better known as NAM, going into my 16th year now. So it's been an interesting run.
Thanks, Judge. So I want to thank our panelists for taking the time to join us. We've got repeat, quote unquote, offenders here. But I want to thank everybody for giving us the time and sharing your insights, because we can share what we have, we can help other people, and hopefully we can advance the knowledge and the ability to resolve these cases and to handle these cases. So our topic today is resolving complex and multi-party litigation. So let's start off by taking a little bit about the big picture. So complex and multi-party litigation. It's not just asbestos cases, but it could be any number of types of cases. Ken, other than asbestos cases, you have other sorts of multi-party litigation. Can you give us a little bit of insight into what kinds of multi-party litigation you've seen throughout your career?
Oh boy, it could be almost anything, but something that comes up quite often is construction defect litigation, where you might have a condominium or a hotel, office building where there are multiple contractors involved, and there are some types of defects in the construction work. And for example, the homeowners association will then sue the contractors for what's perceived to be faulty work. That's one example. Other examples are other types of mass torts, such as lead paint exposure or exposures to toxic substances. I'm working on a case right now involving something that I had never heard of before called Tenorm, which is technologically enhanced nuclear products, which are heavily governed by CERCLA. And we have a case here in Buffalo involving some Tenorm, which is a problem when you're trying to sell a piece of property, as you can imagine.
Yeah, thanks, Ken. Neil, you have a national practice and you do a lot of work across the United States, and also you do a lot of coverage work. Are there complex and multi-party cases just involving coverage that you've been involved in or that you've seen?
Oh, absolutely. So, for those who don't know me, let me just turn my phone off here. Like Tom said, I do both defense and coverage work. I'm one of those lawyers who do them both. But if I'm looking at things in the coverage bucket, absolutely there's multi-party complex coverage litigation. So many of them are derivative out of construction defect suits that Ken was just mentioning. So if you've got a big construction defect suit, odds are there's a spin-off on the coverage. And I defend many coverage litigations arising out of construction defect claims. I've had complex coverage cases arising out of class action suits involving, for example, price fixing in student housing across the country. So it can really spin off from so many things on the coverage side. And as Ken mentioned, on the defense side as well, you might have a catastrophic singular loss that spins out a huge case. For example, one of the cases I'm defending is the January 9, 2022 Bronx fire. And that occurred up in the Bronx, which had many, many fatalities. I think we're probably up to about 80 individual lawsuits. And I know one of the things we're going to talk about is, do the courts like to have these complex things and how do they handle them? It's actually a case up in the Bronx, like I said, where the court has done a rather good job. They're handling it like an MDL, and there's a lot of plaintiffs' lawyers. Joe, I don't think your firm's involved in this one, if memory serves.
We are actually.
Oh, you are? I couldn't remember if I saw you. Okay,
Yep.
Good. So Joe's firm, among numerous other heavy hitter firms, are in this case. And this is one where the court has kind of grabbed the case by the reins and has now required that there be a standard complaint, for example. So Joe might file a complaint or serve my client with a complaint tomorrow, but the court has held him under no obligation to answer it until the master complaint has been filed. The court has assigned a steering committee of the plaintiff's lawyers. They assigned a steering committee of the defense lawyers, which, I'm on. We're required to do coordinated discovery. Each party cannot serve their own discovery in the case. The defendants had to get together and we had to draft a uniform set so that Joe and his crew don't have to respond to 50 different or more discovery demands. So, complex multi-litigation can take many different hats. We just finished a trial of a case involving it. There were probably 4 or 5 parties, right? But we were fighting against 2 plaintiffs' lawyers in a fire case. And I know one of the things we're talking about is how do you resolve these cases? And so resolution can take at least 2 forms: winning or settling. Sometimes there's sort of a combination of the two. And so we had this case. It was a 10-year-old fire loss. So for those who are familiar with New York law, know my client was staring down the barrel of 90% interest. The alleged damages in this case were $60 million. And my client had a time limit demand for their complete coverage, which was substantial. We rejected it, rejected a high-low, wouldn't even offer money. We went to trial. In terms of resolution, what we did was, no one's outworking us. We filed tons of motions in limine. A number of them were granted. Plaintiff opens. We get their liability expert excluded. Various other machinations go on, and we get their damages expert excluded. After they close, we file motions for directed verdict on a Friday afternoon. Sunday at 6 o'clock, the plaintiff called our claim adjuster and settled. And may I add, we had put money on the table that we took off the table and paid less than what we had initially offered, and it was a mere fraction of the alleged damages. So how do you get to resolution? I can tell you this: if Joe's firm was at the helm, that would not have happened. So I see him
Neil,
smiling.
We're going to get to the resolution in a little bit, but I first wanted to ask. Let's start from the plaintiff's perspective, Joe.
Sorry, I could go on forever.
That's fine. We've got an hour and a half, and
I knew it.
Have no holes barred. But let me ask Joe this question, because he's our plaintiff's attorney. We'll then get the defense perspective, and we'll also speak with Judge DiBlasi. Do you find, are there more complex and multi-party cases now than there were 10 years ago, Joe?
I definitely feel that there are. In addition to the cases that Ken is talking about, which the mass tort cases, the cases that Neil's talking about, where you have a mass casualty, whether it be a fire case, we're handling part of the Second Avenue gas explosion case. I think when you just get down to what we would maybe refer to as run-of-the-mill cases, I think they're becoming more complex with multiple parties, especially in things like the labor law. There's so many different entities that we're seeing that are involved in these cases now that you just didn't feel like you had this 10 years ago. So from the plaintiff side, you're dealing with a lot more defendants in each case, which of course for a plaintiff, the most challenging thing is to make sure that you have all the right folks in the case as early as possible, making sure that you're suing all of the proper entities, and making sure that you're all, in the right place. And that happens as well with a lot of, when you're dealing with bus accident cases, multi-victim car accident cases even can be complex. I was handling a case where there was, 5 or 6 plaintiffs, and, they were all being represented by different firms. And the question becomes at the outset, people are filing in different jurisdictions. So you're having at the outset, you file your case to find out that there's 3 or 4 cases from victims of the same accident who have filed in completely different venues. And so it becomes complex in terms of getting all of those folks, in front of, in the same jurisdiction, in front of the same judge to even get it going. And so I'm finding that there's a lot more of these cases that exist. And like I said, especially in the labor law cases where you're seeing parties added later on, which, we all know that cases get delayed in their natural course, but that really becomes a problem in terms of just exacerbating those delays, that getting everybody in there from the outset is important. We're finding that more and more as time goes on.
Thanks, Joe. Jeff Miller, let me ask you, if it seems that we have more complex, more of the CMP cases, do you attribute that to maybe there's a greater appreciation of risk transfer and trying to shift the risk from one party to another party, which tends to make these cases kind of grow a little bit exponentially?
Yeah, that's a good point. And when a firm like Joe's is involved, like you said before, they want to make sure they have all the players. So whether it's somebody who you don't even think's involved but may owe coverage, that does add to the multi-party litigation and the need to sort out those issues before you're at a table and before you're talking before Judge DiBlasi. The defendants better know their coverage positions and their liability positions so that they don't spend a whole day while plaintiff sits in a room separately trying to work out the things that they should work out before we sit with plaintiff's counsel.
Thank you. Judge DiBlasi, let me ask you from your perspective. You've seen more of these complex and multi-party cases now than you have ever in the past?
Yeah, it's really going off the charts, and not only in the personal injury field. I mean, handling cases where you have plaintiff steering committees and you wind up with 25 defendants, and it could be in any type of case imaginable. But we're seeing an explosion really also on the commercial side. Biotech cases, sports franchise cases, accounting and legal malpractice cases, auditing problems, property damage cases, construction cases. These are all coming in because I think what I've seen over the 16 years that I've been doing ADR is that there's just been a massive buy-in to the concept that, well, if we mediate this, we can save a lot of money, get this over faster, and avoid a trial. And also, I've seen a dramatic trend on the commercial side going into arbitrations with tri-panels. And it's something that didn't exist 16 years ago. The one thing that I will say is different when you're dealing with businesses. People always say to me, well, you're dealing with a Fortune 500 company. To them, it's just business. They don't get excited over paying out money. Oh, no. If you think an insurance company gets excited, wait till you deal with a Fortune 500 company and they're paying out their own money. It is like you are squeezing the last drop of blood out of them to get anything from them. It's incredibly intense. But at the end of the day, again, they like the process because it does get it over with. And ultimately, if they get it over with and they're avoiding continuing legal expenses, which in those cases really usually don't wind up going to trial. They usually end, as most cases do before trial, but very few commercial cases get tried. They're very happy at the end of the day. But there's been an explosion across the board.
Thank you. Judge, let me ask you this question, moving right on to the next point. Is our court system able to handle these CMP cases, or is this something that really, Neil mentions the Bronx, which sounds like they have a handle on it. But from your perspective, having sat on the bench, watching cases now, being on both sides, are the courts set up to handle these complex cases?
That's really an interesting question. I mean, I think there are a lot of components to that. I mean, the first thing is the individual judge who happens to be assigned to it. What's their level of experience in terms of dealing with a complex case? Do they have the type of background that would lend itself to really trying to negotiate that type of case? The bigger thing, as I see it, is the time component. When I was on the bench, you have, let's say I would have 10 conferences in the morning, whether they were preliminary conferences, compliance conferences, status conferences, and I used to handle them all. I would not delegate them to my law secretary because I'd like to knock them out. Then I have a trial that's coming up afterwards. So unless you were to take me, for example, and put me in a designated part where I did nothing other than attempt to negotiate these cases, it's extremely difficult to do it. And I think that's one of the problems that you have in the court system is the time factor. If you have all of these many cases, how does one judge deal with that? How many cases could you actually effectively mediate a day? You certainly can manage them. I mean, that's for sure. I had the IBM methylcellulose case years ago with Union Carbide where we had 250 plaintiffs. And every time we would have to expand the courtroom, anytime we had a conference, we'd have 50 lawyers in the courtroom. we managed it, I think, effectively, and we ultimately got the majority of the cases settled. But you would have to take 2 days out of your calendar to try and deal with something like that. So I think the court system, has really made great efforts to try and deal with these cases effectively. But it's a time factor and it's a resource factor, and I think that's why, again, it shifts over into our area of practice, which is ADR, because you can retain me or any other number of highly qualified mediators, and then have the time that you really need to work this out. Because as we all know, when you get a bunch of people in a room and everybody has purportedly spoken before they've come into the mediation process, once they get in, everybody has a different version of events as to what happened leading up to the mediation.
So now that we've talked a little bit about, CMP litigation and what it can entail, let's move into some of the more nuts and bolts of it. Let's talk about what are the big challenges. What are the challenges for plaintiffs? What are the challenges for defendants in these kinds of cases? Joe, as our plaintiff's attorney, you want to take the lead. What are the challenges that you face as a plaintiff's attorney in this instance?
Sure. And thanks, Tom. It's a great question. I think from a plaintiff's perspective, the largest aspect of the case that when you're dealing with it, because you're dealing with a client who has a lot of stressors on whether it's a man or a woman with respect to, their lives have been turned upside down in these catastrophic cases. They've got economic and financial difficulties if they're not working. So time is a really important factor. And so going back to what I said before, from the outset, making sure that you've got all of the parties that need to be there in the case from the outset. The last thing you want to do is get a year into discovery to realize I've left out a party or two that I've now got to bring in through information I've learned, and I've got to go back and start all over again.
How do you go about making sure that how do you go about making sure that you have the right people in a big complex case? Is that a whole other set of challenges?
Sure. I think at the outset, doing your due diligence in an investigation, whether you're dealing with a construction accident or anything else, it's making sure that you're doing a thorough investigation before you even file suit. So what you're doing is making sure that you're having investigators go to, whether it be a construction accident, the scene of the accident, pulling every permit that ever existed for that certain construction project, finding out who the registered general contractor is, who the construction manager is, speaking with witnesses to find out who or who is not on the site in terms of entities. And then, quite frankly, speaking with your colleagues on the other side when you bring them into the case. And one of the first questions I ask, if I'm speaking with Jeff or Neil or anyone in the case is, hey guys, am I missing somebody here? Is there a subcontractor that you're aware of that obviously they're maybe interested in getting coverage from? And speaking with your colleagues and asking, am I missing somebody here? Because you're coming from a viewpoint, you don't necessarily have all the inside information, and trying to get that information as quickly as possible. Because what's going to happen is the discovery phase is the longest phase. And you want to make sure that everybody is there for that discovery phase so you can move through it as quickly as possible. And then just from a plaintiff's perspective, and I think this is something unique to our firm of what we do, we're an open book. When a defense attorney sends me a discovery demand, it doesn't sit on my desk for 30 days. It goes out 24, 48 hours later with copies of record, all the authorizations they need. I don't quibble over things that I think they're entitled to, or at the very least, if it's a question, I'm probably going to turn it over anyway, because the quicker I get it to them, the less we're going to fight about things that we don't need to fight about, the quicker we can get on with moving forward with the litigation. So I think if you can do those things and you can streamline the discovery process as quickly as possible, you'll be in a much better position to alleviate the concerns that your client has in terms of how long is this going to take? How am I going to support my family because I'm not able to work? And those are just some of the things that we try to do at our firm to make it a shorter litigation, to get it to the phase of resolution, whether that be coming to Judge DiBlasi, who facilitates those resolutions, or getting the case onto the trial calendar and a trial date.
Thanks, Joe. Neil, let me ask you from the defense perspective, and we'll ask a couple of people, but from your perspective, as you handle some of these larger cases nationally and some of these other cases, say, for example, a big fire case, what are some of the biggest challenges for the defense attorneys that you have encountered?
So there's a couple of challenges. And before I get into that, let me say one thing. Everybody has the ability on this. If you have a question, you can put it in the Q&A or the chat.
Thank you.
And we will answer that question. Promise we won't tell your name. Number two, I can guarantee if you've got a question, someone else has it. Every question's a good question. So go ahead and ask and we'll answer. In terms of issues with the defense, Tom, it actually falls into a couple of buckets. And I take the word, let's take it in the context of multi-party where there's a lot of defendants. And I can put this in the context if I'm defending a coverage case, if I'm defending a bodily injury case, a fire, some catastrophic case. I find one of the big problems in multi-party litigation is finger pointing among the defendants. And of course, the name of the game is risk transfer and trying to lay the blame off on someone. But I often see lawyers who fight for the sake of just fighting without seeing the forest through the trees. And I often find lawyers who do that usually get the short end of the stick. And when that's going on, a great lawyer like Joe is sitting there going, look at these guys fighting. It only makes my case worth more money. And so often, once you're in discovery, things become so unbridled. I'm involved in a massive case right now that's pending in Abilene, Texas. There is tons of finger pointing. It's a catastrophic fall in a wind tower. And there's so much of this going on, and it's a huge plaintiffs firm out of Houston, and they love it. And so to me, when I see that going on, I try to tamp it down from the other parties because I try not to engage in that. Will I pursue other parties who I think owe it? Yeah. But I try to keep it above board and professional. So often lawyers don't do that. So I find that as a huge issue in multi-party litigation. In terms of complex litigation and how you get your arms around things, it goes to exactly what Joe was saying. You have to do your investigation. A complex case can be a one-on-one case. It doesn't have to be multi-party. But if I'm defending or prosecuting a complex case, I better know my case, right? And so that helps with everything.
And or prosecuting as a third-party defendant, right, Neil?
Well, I might be affirmative. I might be prosecuting as a third-party defendant. Maybe right. I've initiated a commercial litigation. Maybe I've initiated a coverage litigation. I've got a case going on right now in the Southern District involving the failure of solar arrays in California. Before I put that into suit, you bet your bottom dollar, I better know what I'm doing before I file that complaint. Spoken with my clients, gone through the contracts, understand the documents, because that's another problem with, complex litigation. Very often lawyers don't know their case. Sometimes you figure it out at the end, and that's a bit too late. So those are just some of the issues I see, daily. And if I'm looking at it, on a 5,000 foot level, that I'm encountering, all the time. And it's just one point, that you asked Judge DiBlasi earlier, whether the courts are able to handle these cases. Here's one of the frustrations clients have that we all have to always tell them, especially in a case where maybe there is big, complicated briefing and it gets submitted to the court. Maybe there's even that thing called oral argument. And then the question I will invariably get is, Neil, how long will a decision take? And I say, I have no idea. I could say, if I tell you 6 months, it could be 2 years. And that's sometimes, and that's not a knock on anybody. I think it has to just do, certainly in state court, with the sheer volume of cases being filed. But I'll tell you, I have cases in federal court where I can wait a year for a decision. So, there's no rhyme or reason. So that's another factor in some of these more complicated cases where a judge is inundated with tons of briefing that they have to get through. Clients want resolution, but often it just, it moves slowly.
Thanks, Neil. Ken, from your perspective, and you've handled a lot of these cases, especially at the asbestos level, what kinds of challenges do you find for defense attorneys and plaintiffs' attorneys from your perspective?
Well, as Neil was saying, the issue is always risk transfer. The difference between what Joe does and what we do in some ways can be that we have to have a little bit more of a holistic approach. And that is, we have to look at everything, the contracts, the coverage issues, indemnity, additional insureds, contribution. We're looking at all of those things and taking Joe's facts and plugging them into that and trying to figure out what is the best way for us to make sure that our clients getting the fair deal, getting what they bargained for in their contract. And another issue that is becoming way more important as time goes on, especially in the mass tort arena, is successor liability. There was just a case out in the Court of Appeals, I believe it was on Friday, regarding successor liability with respect to coverage issues. And, the law has been for quite some time that, an asset purchase agreement is not subject to successor liability. And I think we're going to start seeing that eroding a little bit. There was some language in the Court of Appeals decision talking about the notion that two sophisticated entities that may be transferring assets should be doing due diligence and knowing what it is that they're buying, both from the aspect of assets but also liabilities. So those are the kinds of things that I'm looking at on a daily basis every day in my cases to figure out, if I'm attempting risk transfer for my client, do I have the right entity? And, did that entity purchase the assets, or was it a merger with some other entity? Because my job is to go out there and find any additional coverage that I can possibly find.
Thanks, Ken. Judge, let me ask you this question, which we've been talking about. You have a good handle on this. How do you resolve these CMP cases easier?
Well, that's a great question. I don't know if there really is an answer to that. What I see in terms of the biggest single problem that I'm confronted with is that no one really communicates prior to the mediation when you have multiple parties. They don't talk. And very often what I feel would be important is if they had a conversation with each other in terms of how they were going to apportion liability at minimum and what the parties think the case is worth. Because even though you can apportion liability, you may have someone say, well, we'll accept X amount percentage in terms of paying towards an ultimate settlement. But then the next question is X amount of percentage as to what? What's the percentage? So very often what I'm confronted with is I have a plaintiff at a mediation, and of course my setting is very different. And then I have, multiple defendants at the mediation, and I'm spending so much of my time talking to the defendants, trying to work out the liability aspect of the case, that the plaintiff is sitting, by him or herself in another room, wondering like, what the hell is going on? What I do now, I've learned over the years, I check in every 10 or 15 minutes and say, listen, I'm working, I'm trying to do my best, and I'm trying to move this along. In my opinion, where you have these multi-party cases and the defendants have a dispute with respect to how they're going to whack up liability and also a determination as to what the case is worth, I really believe that a defendants only mediation would probably be really worthwhile. Let the defendants get together without the plaintiff being present. let them work out their differences, or at least find out if they can work out their differences. Because if they can't, why compel the plaintiff's attorney to come to a mediation, pay for the cost of mediation, where with multi-parties is usually up to about 8 hours, and sit there all day, and then potentially get absolutely nothing accomplished if the defendants can't come to some type of consensus as to how they're going to approach the settlement. So to answer your question, I am often very frustrated because I have defendants who haven't communicated with each other prior to the time of the mediation. And then the other thing is, if they have communicated with each other, there is a complete misunderstanding of the various positions of the parties. And then that leads to a fight as to, he said, she said, what did I say before the mediation? What did you say before the mediation? My feeling is, they need to communicate before they come in. They need to have an idea as to how they're going to divide everything up. And if they can't agree to that, in a really complex case, in my opinion, it's really unfair to drag the plaintiff down when it's really going to be a defendants only mediation. So I'm a believer that, and I don't see it happen all that often, but I'm a believer that in these multi-party cases where you've got a lot of defendants, the defendants should get together, do their own mediation, work out their differences on liability, see if they can come to a general consensus as to what the case globally would be worth, so as to fit in their percentage, and then bring the plaintiff in the second time when they're really prepared to negotiate with them. Those are my thoughts on it.
Thanks,
I'll
Judge.
tell you, Judge, I was smiling because I'm a plaintiff in a big PD case. And about 2 weeks ago, I felt Joe's pain. I sat there, I made a demand. I think I waited 6 hours for an offer. That was bupkis. And we ended the mediation.
Well, let me just jump in there. I will tell you, after all these years, and I will tell you, I come out of it feeling horrible. This is the reaction, and I know my colleagues feel the same way. It may not be our fault, but we come out of the mediation really feeling terrible.
You take it personally.
We take it personally. And not that you're offending me, but you're paying for our services, and we know our services do not come cheaply. And we know, particularly on the plaintiff's side, your clients are paying for that. And it's incredibly frustrating for me when we go through this process. And Neil, exactly what you're saying. 8 hours later, I come back to the plaintiff's attorney and say, well, they have an offer of $300,000 as against your $6 million demand. And
wait, were you listening in on my case?
That's it. And it's just, it's so incredibly frustrating to us. And I know my colleagues who I've worked with for years, we come out and say, gee, I'm the best mediator in the world. I had a $6 million demand. We worked 8 hours and I got $300,000 on the table. So, I mean, it's frustrating for us to be candid.
Thank you. Hey, Steve Kaplan, let me ask you this question. I know you've been involved in any number of mediations and ADRs. Have you had the occasion, as Neil has mentioned, or as Judge DiBlasi has mentioned, to try and get the defendants together beforehand, even with a separate mediation, to get things sort of whacked up so you can come in with some idea of where you stand? Has that been your experience at all?
Yes, I've had that happen on occasion, not as often as it should perhaps, but it can be extremely helpful. Otherwise, the mediation will be dominated very often by two defendants or multiple defendants pointing at one another, and nothing is getting done. So that's something that I do think that the defense bar should consider more frequently when they're talking about trying to resolve a case.
Joe, I guess you're in favor of that too, right? I mean, obviously, the closer you can get to getting something concrete, the better it is, right?
Absolutely. And I've been to a lot of mediations where this has occurred. I am finding now that there is an increase in number of defendant-only mediations. But, one of the things I can say as a plaintiff's attorney that maybe falls on us a little bit is have that conversation before you agree to a mediation. An open dialogue with your colleagues on the defense side is really important. And so one of the first questions that, when I'm speaking to one of my colleagues of, mediation is I'll say, well, look, there's multiple carriers here. You don't have to share with me what, if you'd like to, you can, but you don't have to share with me how this is going to break down. But has there been some agreement or some discussion amongst the different carriers on how, how coverage is going to pan out in terms of paying? Because maybe we're a little premature. Have you thought about a defense only mediation. So I think as a plaintiff's attorney, you can also bring that up, have that dialogue before you agree to a mediation. And then all I'll say is, when you're at a mediation and that does occur, don't blow up. Keep your cool. Things happen. Don't ruin relationships and get hot about it. And realize sometimes it's a process that you have to go through. And while it might not be pleasant and it might be a little frustrating, you have to go through the process and do it in a way that you make sure that you maintain the relationships with the people that you work with.
Thanks, Joe. Jeff Miller, let me ask you, you've done a lot of mediations and many on complex cases and multi-party cases. Do you find that the posturing, which can typically take place between defendants not wanting to, own up or not wanting to tip their hand, can work like Joe and like Neil and like Judge DiBlasi and everyone is talking about, in the inability to even get to square one and get an offer going to resolve a case?
There's always a lot of posturing and card playing, and even with people that are straight shooters, there's got to be some back and forth. But at the end of the day, it's a great practice to try to get some of that stuff out of the way. And we've done defense-only mediations that have been very successful. Times they take time, but better than doing it with plaintiffs sitting in a room next door, sitting 8 hours stewing that they haven't gotten an offer. So I'm a big proponent, and I think it's very useful to get a defendants-only mediation. And even if there's some posturing back and forth to start it, it usually gets the ball rolling. And when you have a skilled mediator like Judge DiBlasi, they'll come up with ideas and help facilitate some movement amongst the defendants.
Thank you. Thank you. Joe, is it tough when you have one of these 6-hour mediations and you get $300,000 offer? Is it tough going back to the clients and saying, look, I know you had a great expectation. I had expectations, but we're not there. How do you deal with that?
It is. And I think you deal with it well before the mediation. So you should have dealt with that in the years that you've been representing the client by making sure that you have really, really constant communication, a lot of meetings, establish a trust with your client, which we do. And that way the client knows going in, and you set those expectations. And I think when you set expectations, give them the reality of it, that sometimes mediations are a process. And sometimes this first mediation won't result in a resolution, whether it be that the defendants haven't agreed amongst themselves of who's going to pay, what percentage, what amount, or it's used as a position to see, hey, is it something we can get the plaintiff to bite at a number, that is a much happier number for the defense to pay. And so I think if you just set expectations, establish the trust with your client over years, when you do come back from that first mediation, it hasn't worked out the way you want it to, there's less likely that they're going to get upset or that they're going to really be frustrated by it. And I think that's really important for any plaintiff lawyer to know, is you've got to sit down and establish that trust with your client in the years leading up to the point where you get to a mediation.
Thanks, Joe. Neil, the same applies for defense, right? You have your clients, and you can go away from the mediation with a lot of bruised feelings and whatever, because you got nowhere fast.
Well, yeah. And so I was sitting here thinking, if someone was to ask me a question in the chat room, well, Neil, what's an important point? Complex litigation or any litigation? I'd say there's at least two facets to it. Preparation and having an understanding with your client, right? So if I'm going into, I don't care if I'm going into a deposition, I have a strategy. If I'm filing a motion, I have a strategy. And for certain, if I'm going into mediation, I have a strategy. And it becomes even more important in a complex case. So, we keep throwing the word complex. One of the most important things a good lawyer does in a complex case is make it simple. And so the only way you're able to do that is by massive preparation and knowing your case. And then your client, could be talking to you, and they're very concerned, rightfully so, because they see a lot of these things. And I think what helps to get their mindset in the proper frame is by taking the complex and making it simple. Doesn't mean it's easy, but you try to break things down by points, by issues. And I do issue trees when I work on things. I'll have a concept with the documents that support it, and I can quickly and effectively convey these things to my clients. They don't want to read a 40-page report. They want to read maybe 5 pages. Tell me the story. And so I think when we're talking about complex cases and what clients want and frustrations or things like that, it's our job to know it, make it simple, convey it, so that when you ask perhaps for settlement authority, you know what your case might be worth. Or when you're asking your client for a certain amount of money and they say, well, what's the strengths and weaknesses in our case? You can actually articulate that in a concise way. You might say, I've got this document, I've got this document. Here's the way this works. Here's why. I'm sure Judge DiBlasi would say this. If I'm arguing a motion before a judge, I see lawyers who are all over the place. I'm going in targeted. I know my stuff. Here's a couple of things. Get in and out. So I think that's such an important point when you're talking about, again, complex. It goes to any case, but when we throw around the word complex, I think of a case where there could be tens of thousands of documents, or there's complicated legal issues that you have to parse through. But in any of these cases, you've got, again, it comes down to, you got to know your case and you got to simplify it for everybody. And that just kind of that's kind of the way I look at things.
Excellent point, Neil. Thank you so much, because that's a really big practical consideration. And I want to move to another practical consideration, because I know that I've helped Scott Miller, I've helped Scott and Steve Kaplan on some of the larger cases that they have. And some of those cases are going on 15, 17 years. It's almost like having a child grow up in front of you. So let me ask Scott, what can be done to shorten the lifespan of these CMP kinds of cases?
That's a good question, and it's not always something that can be shortened, but very often they can be. I've got one in which there were 11 plaintiffs, and we've whittled it down to 5 plaintiffs at this point in time. Granted, the ones that we were able to get rid of were not the larger cases, but even so, looking at each claim in isolation and each plaintiff in isolation and figuring out what can be done in the short term to get rid of some of them on the cheap is a strategy that often works. And it's a lot more manageable in scheduling things when you don't have 11 plaintiffs' attorneys that you've got to consult with and only have 5. So that's one approach.
Thanks.
Another one is with the risk transfers, to the extent that multiple parties can potentially be represented by the same firm, and the only thing preventing that are all of the reservations of rights, which are routinely placed in a coverage letter, some of which will never come to pass. Sometimes you have to take a good hard look at whether those reservations are really protecting the carrier or whether they're preventing the carrier from consolidating the defense and resulting in increased defense costs.
Thanks. Ken, let me ask you the same question. What have you found can be done to shorten the life of some of these larger cases, the asbestos cases, the multi-party cases, and things that you've seen in your career?
Well, my experience has been that the best way for me to represent my client is to know what it is that they're doing as intimately as possible. One of the first cases I had when I came here to Pillinger, Miller, and Tarallo involved a construction defect wherein a hotel in the southern tier was being undermined because there was construction going on next door. And I had to learn all about construction of high-rise foundations in order to do that. And, you know, I worked with my client, went out and met him, had him show me videos of how things work and what have you. And by doing that, and by learning about what it is that they were doing, I was able to get the case resolved early on because I knew what I was talking about. When I deposed the plaintiff in that case, I understood what the issues were as well, or hopefully as well as my client would have. That way, I was able to get to the meat and potatoes of it, what really the issues were. That I found was incredibly important. And I've done that, you know, with other clients in my career. I have represented construction product manufacturers of things like skid steer loaders or backhoes, cranes, things like that. You have to really know everything that you possibly can about the product and about the incident. And if there's a problem, then, you know, you're able to attack it right up front and say, look, maybe this is one we should think, you know, about trying to resolve and get rid of it early before you open a door to all kinds of bad things that can happen. Of course, you know, that always is, you know, on Joe's side of the fence, that's the gift, right? I mean, when he said earlier, you know, he's sitting back and watching, you know, defendants go head on head. You know, that's a problem because, you know, if I've got a component part manufacturer as my co-defendant, you know, they may come up with things that, you know, everybody doesn't really want the whole world to know.
Thanks, Ken. Judge DiBlasi, from your perspective, anything that you would add to things that can be done to shorten the lifespan of these cases?
Well, I mean, there are a lot of things that can be done, but I'm going to have to jump back to something because that Joe and you were talking about, because I think it's so critically important. And that is, you know, dealing with the client who's present at the mediation. And what I find, and I wanted to say this because it is something that's critical. I find that plaintiff's attorneys often lose the opportunity to have their client just meet the mediator in the first instance, just so they know who this individual is who's attempting to negotiate a resolution of the case. And I almost feel, and I've always felt, out of my respect for the client, I'd like to meet them and introduce myself. Secondarily, if they want to be heard, and, you know, of course, every case is different. Some attorneys, you know, in terms of their judgment, will say, no, this is not the case where I need my client to talk to the mediator. But I'm not talking about the mediator convincing them to do anything. I'm talking about the involvement in the process, giving them an opportunity to be heard. I mean, particularly, for example, in the CVA cases, the Child Victims Compensation Act cases, it's painful for me to sit and listen to what these plaintiffs describe in terms of what happened to them, but it's a necessary part of the process. Another example I could give, I mediated a case involving a claim where a firefighter unfortunately died inside a building, and his wife was at the mediation, and the case had been, you know, really litigated over a course of years. And one of the first things I said to her when I met her, I said, I just want to tell you, you know, how sorry I am, you know, for your loss and for your children's loss. And this woman looked at me and said, that's the first time anybody has said they've been sorry in the entire context of this litigation in all these years. She's a very bright individual. And she said, I want to thank you for doing that. And it helped get the case resolved. The other thing, and I think this goes to what Joe was talking about, and it's up to plaintiffs' counsel whether they believe it would be helpful or not. But I do think in many cases it is, and plaintiffs' attorneys just don't take us up or ask the mediator to do this. Talk to the client about the aspect of disappointment when the case is not settled. There's a lot I can do to help plaintiffs' counsel with that, and it helps ultimately settle the case. Explaining to them that this is not your attorney's fault, and we can put it in any words that we want, but let them understand that this is something that's not necessarily within their attorney's control. That I did everything possible during the course of the mediation to help get the case settled and to help move it along. That I'll continue to work with the attorneys informally subsequent to the time of the mediation to see if I can get the case settled. And that I think, as Joe said, you have to understand this is part of the process. Sometimes it doesn't work. We know you're disappointed, but it's a very good step forward. And what I often tell people is, we've all been around for a long time. 44 years ago, when I started practicing law, there was no such thing as a mediation. It didn't exist. You had a conference if you were in Supreme Kings before Jerry Held, or in Supreme Bronx before Louis Fusco, and then they sent you out and tortured you for 6 or 7 days waiting to select a jury, and then you ultimately settled it. What I like to say to clients is, this is really actually a great process, particularly from the perspective of a former judge, to see if we can get this case out of the courthouse. And even if we don't settle it today, get it on the right track to see if we are going to be able to do that and try and move it forward. I hate to diverge into that, but I thought that this was such an important point, and Joe and I think Neil talked about it, that I just had to go back to it.
No, we appreciate it. This is when we have our webinars, we appreciate everyone's perspective, and it's free form. There's no rigid agenda. We ask everyone to give us your insights, and insights are always valuable. So thank you very much, Judge. Sure. Joe, let me ask you this question, because this is something that, as a trial lawyer, you would be concerned about, and anybody who would be defending the case would be concerned about it too, which is, what are the practical problems with cases that last forever?
They get stale. They start to stink. That's the long and the short of it. Cases that are old, when you get to trial especially, one of the things you have to deal with is first just kind of educating the jury on, why is this case so old? And educating them. It doesn't mean there's something wrong with the case. It just took this long to get there. As cases go on, from the plaintiff side, there becomes more risk in the sense of, you've got a client that is struggling for many years with injuries, how they feel, medical treatment they need, economic, financial stressors. By the same token, from the defense perspective, it raises the risk of, what other further treatment is this person going to have? Are they going to require a revision of their fusion surgery, which is going to make the case more significant and have a greater value? So those are things that you have to consider. I want to go back to what Neil said before, though, and I think it translates into trial in terms of, keep it simple. What you do during your handling of the case, knowing your facts, as a plaintiff, knowing your client, you want to keep it simple, and that translates into trial. The more complex you make it, the harder it's going to be for the jury to grasp it, to understand it. So I think the same thing, as Neil said, you do during the course of the handling of the discovery, you want to translate that into trial. You don't want to complicate it unnecessarily if you don't have to. And just in terms of shortening the case up, one of the things that I think a plaintiff wants to do is, don't be reactive, be proactive. And shortening the case requires you to be proactive. If you send out a sup BP because your client had a surgery, and that surgery was 6 months ago, and you didn't know about it because you haven't been communicating with your client, and now you've got a 6-month delay because the defendant's going to be entitled to another deposition and another physical examination, well, that's shame on you. You've got to be proactive in the handling of the case. I have attorneys say to me all the time, well, the defendant hasn't provided us with discovery, so I'm going to send a letter. I said, well, why would you send a letter? I said, you don't need to send a letter. You're going to have to draft it, then you're going to mail it or email it, and then they're going to have to see it. Pick up the phone and speak to somebody. You can have this resolved in 5 minutes. Say, hey, Neil, I know you always discovery, and I'm sure you got tons of things on your plate. I'm just giving you a reminder. shorten things up by doing little things like that, and it'll get the case moving forward. So ultimately, you can get to trial, and trial is the greatest way to get a case resolved when you're handling litigation. The threat of a trial, because that's when everybody's risk really, comes to fruition.
Let me just go back for a second and ask. I wanted to ask Joe a question. Joe, when you are encountering a jury and you're trying to explain to them why a case took 10 years, do you find that you get through to the jury, or it's just something that they just say, well, that's the way things work?
No, I found they understand it. I mean, jurors they're people just like we are. I know we fancy ourselves as lawyers and bright and the brightest and the best, but when you really just get down to it and speak in common language with people and just have a conversation in jury selection, they tend to understand it. And while they might, be a little wide-eyed and say, really, that's how long this takes? I think when you give that explanation just in terms of, the courts, the parties, the process you have to go through to get there, they generally understand, but more importantly, they understand that it's not something that they need to consider in determining the outcome of the case. And that's the most important thing, is you don't want that to in any way impact their decision-making process. That decision-making process needs to come from the evidence and the evidence only. And that's the most important aspect of that.
Thanks, Joe. Let's move into another area which is always of interest, and I call it the more the merrier. Let's talk about layers of coverage. Neil, what are some of the considerations, issues, challenges that you find with layers of coverage when you've got a complex, quote unquote, or a MLP case or something that's got a lot of different moving parts like we're talking about today?
Well, I mean, it depends on the nature of the case, Tom, but certainly one of the issues you deal with, and we see this in, in my coverage practice, I see this in virtually every labor law case where, let's assume the employer is the third party defendant. And I'm the GC, I've got a contract with the employer that allows me to sue them, but it also requires additional insured coverage. And so I tender to that third party, and the question let's assume they've got primary and excess coverage. Certainly one of the battles all the time, and I literally just drafted a letter to another insurance company on this, is maybe the primary picks up, but the excess does not agree to vertical exhaustion, meaning they don't agree to apply immediately upon the exhaustion of the primary policy, but rather they want the GC's primary policy to go before the employer's excess policy goes, trying to keep it simple. So very often, that's a fight you fight. And if I'm, if I'm prosecuting that third party case and someone says to me, listen, I'll pick you up, but I'm not going to agree to vertical exhaustion. And I know, for example, I've got a rock solid contractual indemnity claim. And by rock solid, as I tell every single client, if I think I have an absolute winner, I never give you better odds than 75% because I never know what a judge is going to do. So if I think I have a rock solid contractual pass-through claim, I may tell them, you keep your additional insured claim. I'm going to prosecute my third party claim for contractual indemnity. And when I win on that, I will vertically exhaust your coverage because that becomes a covered claim under the employer's policy, right? So that's certainly one of the issues you see all the time. If I'm all of a sudden switching and I'm thinking about coverage in a construction defect case, or perhaps a long tail injury claim, now all of a sudden I'm looking at policies across a huge swath of time, and I have to start thinking about things about what's the trigger, what's the applicable trigger of coverage. Maybe I'm in New York, it's continuous trigger, or if I'm in another state, it might be different. So the coverage issues can vary depending upon the case and depending upon the jurisdiction. Certainly, it goes back to what I said, relative to any case. If you're looking at something, you've really got to study it, right? And so you've got to know if I'm looking at the coverage, what the law is in the given states. I'm literally, right before this seminar, I was working on a coverage claim for someone who got shot in a premises in South Carolina. And so we're looking at the application of a potential exclusion of a policy that was issued in New York to an insured who owns property in South Carolina for a suit pending in South Carolina federal court. And so there's always a lot of different things at play. Certainly, if you're looking at coverage, I'm looking at choice of law. And so there's a whole host of variables depending upon the nature of the case.
Thanks, Neil. Let me ask a question to Judge DiBlasi. Judge, what challenges do you find with layers of coverage in resolving these cases?
It's a nightmare. It's an absolute nightmare. I don't even know what to say.
That was easy. That was easy.
That's like that's my answer to it. It's an absolute nightmare. Typically what happens is we'll have the initial mediation where I have this going on right now. We have a brutal battle over coverage. The parties can't work out coverage at the time of mediation. And again, we have the plaintiff sitting there waiting. And then ultimately, and this happened last week, the parties finally get on the same page as to coverage, except for one problem. The case is now on for jury trial next Friday in Supreme Bronx. Now the plaintiff's attorney is not going to take what he would have taken at the time of the mediation. So, I go back to the same thing. I mean, it's sort of like a mantra that I'm chanting at this point in time. The parties have to really, the defendants carriers have to get together and try and work that out in advance. And I also think, again, a comment that Joe made is a good one from the plaintiff's perspective. Take the opportunity to talk to them, because I often find this is the confusion I'll have with plaintiff's attorneys. They'll say to me, I didn't realize there was a coverage dispute. And this is actually something that comes up very often. I'll have the submissions from the parties. We start the mediation, and then once the mediation has begun, for the first time as a mediator, I am told we have dispute as to coverage. It entirely defeats the process. So my thoughts are, the plaintiff's counsel should have a conversation with the defendants and just say, hey, I know we may not necessarily be able to work out everything prior to the time of mediation, but have you talked about coverage? Are there disputes? Do you think it's going to be reasonably possible that we can, resolve this at the time? And then on the side of the defendants, carriers, they have to talk prior. And, I think just the way the world has become, nobody wants to talk directly to each other anymore. They don't even want to, at times during the mediation process when we have issues involving coverage, I'll say to them, look, I can take messages back and forth 15 times. But, it's like telephone. I become a filter for the messages. Now, sometimes that's good when I have two parties in separate rooms who are screaming at each other. But when we start getting into technical arguments over the issues of coverage, to try and have the mediator go back and forth and advance the arguments or the defenses on one side or the other is almost impossible. What I'll say to the parties is, listen, why don't we reassemble at this point in time in the same room and have a direct conversation? Do you know 9 out of 10 times the answer is, I don't want to do that. I want you to do it. And it's incredibly frustrating for me because it reaches a point, there is a point in a mediation. If a mediator says to you, let's get together and talk face to face, let's clear up any misunderstandings that we have, or at least if this is going to go south and it's going to tank, let's have a very clear understanding of where we agree and where we disagree. I find it, it's a nightmare. People don't want to speak directly. They don't want to talk about it beforehand. They sometimes will surprise you at the time of the mediation, not let you know as the mediator that there's a coverage issue. For that matter, many times I've had plaintiffs walk into mediations. Not only do I not know there's a coverage issue, plaintiff's attorney says to me, what coverage issue? What coverage issue? Nobody mentioned this to me.
I do feel the need to say something here. Because I'm going to put my defense practice aside. So many people cringe when they say the word coverage. I don't know. I like it. I embrace it. It's like it's doing like any kind of contract work. So for anyone out there who I might work with, I love coverage. It's fun. It's something totally different than doing the BI stuff. That's just by adding a little levity. Anytime I start talking coverage with someone, they cringe, unless they're another person who does coverage. And then we have a wonderful conversation.
Neil, nothing brings a smile to my face faster than multiple layers of coverage.
Yes, and speaking of multiple layers of coverage, I wanted to ask Ken Krajewski.
That's fantastic.
Ken, how do you manage conflicting expectations, and strategies with layers of coverage.
Gave me a good laugh.
Oh, and you know, that could be a challenge. That could be a real challenge. Because you know what the judge said is absolutely true. They don't want to talk to each other. They want to use us, whether it's defense counsel or the mediator, to be the carrier of the message, and it can be very challenging to try to do that. I did resolve one recently. I was successful doing that by getting them to email each other and outline their positions, so that at least as between the two, they were able to come to an agreement with respect to potential coverage problem as a third-party defendant who had an order then requiring us to defend and indemnify the primary defendant. But you know, there's always somebody always wants to bring up a point that somehow or another they think a court overlooked or missed or something like that, and they want to make sure that they can do it. It's very challenging, and I think what the judge said is it couldn't be truer. Let's try to get everybody together so that we have a free flow of information, and I'm not being asked to interpret, and not that I'll do it. I'll do what the carriers want me to do, but the better way to resolve is to get people talking. That's been my experience.
Thanks, Ken. Steve, let me ask you this question, because I know from having been exposed to some of your larger cases that you have, again, multiple layers of coverage. The carriers have different expectations, different strategies, different points. How, from a practical perspective, do you manage all of those and not have on your side all of the infighting that can make it so difficult to move forward with, say, trying to resolve the case?
Probably the best way is to engage the upper tier carriers to understand that resolving the case sooner will save them money, because there's always an incentive for those who aren't paying defense costs to sit back and allow the case to just linger on. Their money's not at stake. But if they recognize that they could get a deal now that they won't be able to get 2 years from now, they have more of an incentive to be willing to go to mediation that much earlier and resolve the matter.
Doesn't that also presuppose that they've said, okay, the primary policy is up, and now it's within their ambit to
that is true, yes, and that's a matter of how one evaluates the exposure and explains that to the entire chain of carriers going from primary up to the top.
Thanks. And Neil, of course, you want to have that conversation as soon as possible, right? So you can try and get the upper level, the higher level carriers with an eye towards moving the case sooner as opposed to in the next decade, right?
Yeah.
Oh, yes. The short answer is yes. But that again goes back to the basics, knowing your case and properly evaluating it. And if you think it's a case that has exposure above a primary level, then one would hope the excess carrier already knows that well in advance of mediation, so you're not springing it on him a couple days before. So
let me ask you this question. With self-insured retentions, and we know many companies now, because of the fact that the policy premium would be varied based on the self-insured retention. So many more companies, many more insureds have self-insured retentions, and some of them are substantial. Do you have additional challenges dealing with self-insured retentions?
You talking to me?
Yeah.
Oh, okay. Well, I mean, I see feel like I'm a
Yes,
taxi,
Robert De Niro.
a taxi driver. Exactly. You're talking to me.
You're talking
So,
to me, yeah.
yeah. So, I mean, to me, large SIRs, I generally find with companies that are large manufacturing concerns, perhaps governmental entities who have a tremendous SIR where the policy almost in effect becomes fronted for the amount of the SIR. Does it create challenges? Well, it can. It certainly can. And very often what you have to do is revert to the language of the self-insured retention endorsement in the policy to see both what the rights of the insured are relative to the risk while it's in the SIR and what the insurer's rights are, even if it's within the SIR. For example, you might have a self-insured retention provision that still has a hammer clause in it, a hammer clause being if the insured has the ability to settle the case within the SIR and they do not do so and the insurer recommends it, if they don't settle and the case goes above the SIR, then they have to eat the risk. So there certainly are different challenges, I guess is the word you used, when there's an SIR, but it kind of goes back to a concept I mentioned before. An insurance policy is a contract, and you have to understand the parameters of your contract, whether you're the insured or you're the insurance company evaluating coverage. But definitely when there's an SIR, it presents issues. For example, if the insured is bankrupt and can't pay the SIR, right? I won't get into that whole long discussion of that now, but if they go bankrupt, then there becomes questions about when the primary policy effect comes into play, when does the excess policy come into play, when the SIR can't be satisfied. So there are definitely challenges and definitely issues, all of which have to be evaluated.
Thanks, Neil. Judge, from the ADR perspective, what kinds of challenges do you encounter with self-insured retentions?
Well, it becomes like a show game at times because the SIRs, let's say hypothetically 250, 500, whatever it happens to be, and the self-insured party is not really too worried about the case going to trial and losing their self-insured retention because they know they have protection above that amount. So what they do is they try to hold out as much as possible and see if they can get the plaintiff to cave, which generally speaking is not going to happen. So I mean, the challenge that I see is getting them to understand that they should move out of that. Sometimes it's just very, very difficult. I deal with a lot of box stores, for example. They have an SIR. The worst case scenario is they have very large SIRs. When you get into the big chains like Target, Walmart, those types of chains, and they have their own claims people, and their claims people are, I deal with them directly and I deal with them repeatedly. And it's like, getting blood out of a stone, getting them to put the company's own money on it. And I know them. I mean, I could name any number of these large corporations where I know the in-house people. And it's interesting, they were either plaintiffs' attorneys or defense attorneys at one time, and then they went in-house with these corporations. So they know exactly what's going on, and they have a certain amount of money. And I think, the companies with SIRs, the larger ones, they have a completely different philosophy than insurance companies. They just don't want to pay. It's just as simple as that. And that's at least what I'm encountering. They don't want to pay. And it's a challenge, and you have to work through it. How you get through it, every case is different. There are pressure points in every case. Sometimes you do have, I think it was pointed out, the carrier can start exerting pressure on them if there's a clause that, that they put them on notice to settle within the SIR and they don't. They could be on the hook for, a judgment after that. But generally speaking, they're very difficult. And when you're dealing with the corporate people, they're impossible. They're really impossible. That's, just been my experience.
Thanks, Judge. Joe, from the plaintiff's perspective, let's turn it around and ask you, what challenges, obviously, do you find with these self-insured retentions and breaking them down to the point where you can move to talk about getting the case resolved into the next layer of coverage?
Right. Well, you need to know what your role is, and you need to stay in your lane. And from the plaintiff's perspective, obviously, we're not representing the entity, the insurance company, but what you can do is you can highlight the risk. you can provide the information that they need to evaluate your case, and do it early, and do it detailed, do it credibly. Don't wait until 60 days before trial to disclose your economics. Don't wait a year after a surgery to supplement your bill of particulars. Don't wait until the last minute, the 11th hour, to present your demand on the case. Get this information to the defense early, get it done in detail with credibility, and that enables them to at least evaluate the risk going forward. So you might have an SAR, and then you might have multiple layers of coverage behind that. At least present to them your view of the universe of what that exposure is. And that at least, hopefully, they'll look at that, and maybe they'll make a decision sooner rather than later, based on the information that you provide them with. And that's, from a plaintiff's perspective, what you can do. And then in terms of just, going forward, you hold your ground, prepare your case for trial. And if they're not willing to meet you where you need to be to resolve the case, then you try the case, but you've got to show your readiness and your willingness to try the case. And that's really, I think, from a plaintiff's perspective, really what you can do.
We're just about out of time. If there are any questions from our audience, be happy to take them. All questions are good. We welcome all of the questions. Neil, do you see if there are any questions there?
I see no questions.
No questions.
Come on,
Well, then-
anybody, a question, something.
Neil, I have a question for you.
Oh no, here we go. Go ahead.
Neil, did you see yesterday's decision, I think out of the First Department, about the CVA coverage?
I did not.
Apparently, Chubb won in the First Department, arguing it had no duty to defend and indemnify the Roman Catholic Diocese of New York for CVA claims, Child Victims Act claims. For those who may not know, one of the arguments they made was that the Archdiocese clergy and employees hid crimes and protected the perpetrators, and punished and stigmatized those victims that came forward. I really was shocked to see that decision.
I'll have to read it, because I can tell you, for high-level excess carriers, I have done coverage work on those, denied coverage, and that's an interesting decision. Definitely, I'm gonna have to take a look at it.
I thought it was an unusual decision that it went deep into the claims relative to not the timeliness issue of it, but the fact that there was purportedly on the part of the diocese, and I'm not judging here, I'm just talking about what the decision says, and that is that the diocese took an active role in trying to conceal this information. I thought that was
Thanks, Ken.
unusual.
Appreciate it.
No, thanks. If you have it handy, Ken, if you can flip it to me, otherwise I'll pick it up on Westlaw. That would be great.
I'll email it over.
Thanks so much.
I think we've come to the end of our webinar. I want to thank once again all our panelists for spending the time and your great insights. These webinars, you guys are the content and you guys are the panelists. So I want to thank you for that. Thank you for letting me moderate it. I want to thank St. John's for their contributions, and I want to thank PMT for our ability to put these on. Thank you for all the panelists, Joe Donahue for taking his time, Judge DiBlasi for spending his time once again. You guys are, yes, as I say, repeat offenders, so I thank you for being here. I think, did I see a question up there? Is there a question? Thank you for all your input. Okay, well, you're very welcome. So on behalf of PMT and St. John's Greenberg School of Risk Management, I want to thank everybody. Thanks for spending part of the afternoon with us.